Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
And it's my understanding it will be an evidentiary hearing, so you may call your first witness.
Pass up a certified copy from General Sessions Court in Dixon County. New arrest from August the 1st for Ms. Rebecca Miles showing domestic assault with the allegations stated therein. We may have rebuttal proof, but at this point, that's the state's proof for the direct purpose, Your Honor.
I object to admission of that document. Violates confrontation.
Your Honor, I believe literally out of this county with Judge Locker Mash, that went up to the Court of Criminal Appeals. The Court of Criminal Appeals ruled that that was sufficient on its own. I'm trying to get the exact case. I could find that out, but that literally came out of this very circuit court county, Your Honor.
I don't have the case in front of me, but I'm understanding that is the rule that has been adopted by our Court of Criminal Appeals. So as a result of that, I will have this marked. It is a certified copy. I'll have it marked as Exhibit 1, and that is the state's proof under the statute, which allows the state to seek the revocation of bond based on a subsequent arrest for a person who's on bond. Is that correct? All right. Mr. Flanagan, do you wish to offer any proof?
Maybe. This motion to revoke bond, and that's the DA's office here always styles it that way, but they leave off the other options. It's a motion to revoke, alter, or amend. So this thing that's been handed to you as now an exhibit is maybe sufficient to show that the bond condition has been violated, but the court has discretion on what to do with it. And so I think that's where we are. So if the court is now ruling that they have sustained that the bond condition has been revoked, then we'll go to what needs to be done.
Well, based on that case that Mr. Stevens has referenced, is in my own understanding of the current state of the law, a certified copy of a subsequent arrest record is admissible, and under the statute that the state is proceeding under, they have the right. It doesn't require conviction. It says anyone who is on bond or in bail and is arrested on a subsequent offense, that the court has the option of revoking their bond. So yeah. I think that the state has met its burden to show that there is a basis for the court to consider any revocation of the bond, or as you state, the statute allows for modification of the bond. So the state, in my opinion, has met its burden to show that there is a basis for review of the defendant's bond, either a revocation or a modification. So if you wish to offer any proof about that, then I'll be glad to hear it. So. Well,
I guess my position is now, has the state put on enough just with that to justify a revocation of the bond? I mean, that's all the proof you have before Your Honor. So you got three choices. You can raise the bond. You can put different restrictions on her. So my position is they have not met the burden to show that one of these other options is not appropriate. So I'm asking the court, as a matter of law, to alter or amend the bond.
So you're basically asking me to alter or amend it, okay?
Yes, because
I understand what you're asking.
Yeah, they put that.
Let me hear what the state's argument is. If we're not going to have any proof, then I'll let you both argue what you think the appropriate disposition is.
Well, let's do it this way.
Okay.
Would you state your name for the record and please spell it?
Shonda Vargas. It's SHONDA VARGAS.
Okay. Ms. Vargas, where are you employed?
Serenity Ranch Recovery in Mammoth Cave, Kentucky.
Serenity Ranch?
Yes, sir.
Okay. And has Ms. Miles already been admitted there?
Yes, sir.
And
Turn your microphone on.
A new charge you've already carried the burden on that, General. New charge has occurred. We're talking about disposition.
So just to clarify, is this, so as Mr. Flanagan seceded the point that his client violated the conditions of bond, and this is for the purposes of what to happen? Because at this point, I think it's irrelevant to whether or not she picked up new charges while on bond.
The court's already ruled in your favor on that, General.
I have ruled, as a matter of a finding that I've made, that the introduction of this certified copy is sufficient to meet the burden that the state has to show that there is a basis for the court to consider whether or not to revoke the bond. So I've made that finding. Mr. Flanagan is now wanting to produce proof that would offer alternatives to the actual revocation by offering, I'm assuming, some testimony that would indicate there is a basis for a modification of the bond, which is one of the options that the court has in this particular case. So as far as relevance, it is relevant, and I don't know, I haven't heard everything, but if it's relevant as to what the defendant's present situation is and what, if any, modifications should be made versus revocation. So I'm going to, unless you have some other basis for the objection, I'm going to allow it to proceed.
Yes, sir.
Tell the court about the program.
It's a 28-day detox and residential program where we help individuals overcome substance abuse disorders. And we also deal with mental health, so we are dual diagnosis. After the 28 days, we do help clients go to the next step, which would be a partial hospitalization program, a PHP. We do help them get that set up if that is something that they are interested in to continue their recovery, to help them in that sort. We have therapy, we offer therapy, case management, and things of that sort, also group therapy. It's just kind of to get them to go on to the next step in their recovery.
Okay, so she's been admitted.
Yes.
Been there a couple of days, right?
I want to say she's been there about a week, but I'm not
Okay,
positive
about a
about
week.
that. Yeah.
And she'll be there for at least 28 days?
Yes, sir.
Could it be longer?
Not in our program, but we can set it up so she can go straight from our program to another program that would be 30 to 90 days.
Okay. And at my request, you brought her here today because you knew she had to be in court.
Yes, sir.
If she were to leave the program, would you notify me and/or the district attorney and the court that she left the program?
Yes, sir.
That's all I have for you.
Stevens, do you have any questions? You don't get off that easy. The state has the right to ask you questions.
This is kind of nerve-wracking.
Good afternoon, or good morning, ma'am.
Yes.
Just a few questions for you. So when you go through that, are you aware of any of her prior charges as part of this when she goes into a program?
Yes, sir.
Okay, so you're aware of about 20 prior domestic charges?
I mean, I'm not personally, because I don't do the admission part. I work with the clients on a daily basis. That's all. That's my job.
Okay, what about 20 prior charges for violating conditions of bond?
Again, that's not my job. I don't do the admission part. I just help the clients when they come in.
What about 5 times failing to appear?
Again, that's not my job. I don't work with the admissions. I don't know what we know about her prior charges, but I do know that she had charges because we brought her to court today.
Are you aware she's a convicted felon for aggravated assault?
I mean, most people there are.
Okay,
Yeah.
that's all that I have. Thank you.
Nothing further this witness.
Thank you,
If the
ma'am. You
court
may step
doesn't have
down.
any questions.
Any other witnesses?
No, Judge.
State wish to offer any proof?
Her husband, Mr. Robert.
All right. Mr. Robert Miles?
Yes, sir.
It has to do with the disposition. And Judge, before we get started, because I don't represent him, he is the victim in this assault. I think the state is going to ask him questions about what happened. And I explained to him that if his testimony here today is different than what he hold the officers, he could be charged with filing that law. I don't represent him. If the court wants to caution. I told him I don't want to put him, that's why I didn't call him, because I didn't want to put him.
Mr. Miles, well, first of all, Mr. Stevens, are you intending to ask him about the factual basis of it?
I am, Your Honor.
Mr. Miles, you are the alleged victim in this case that's being used by the state as a grounds for the revocation of Ms. Miles's bond. In that, the officer who made the arrest is stating that you gave him information that, and I'll read this to you. It says, I made contact with Joseph Miles in front of the residence while Sergeant Mutter spoke to Rebecca Miles on the front porch of the residence. Joseph explained that him and Rebecca were eating Chinese food in Bellevue. Joseph stated him and Rebecca got into a verbal altercation at the restaurant. During the verbal altercation, Rebecca stabbed Joseph in the right hand with a fork. And then it also says that once you returned to your residence, Joseph stated that when he turned on Trace Creek Road, Joseph stated Rebecca started striking him in the face, chest, and groin. And I noticed a bruise under Joseph's right eye. So what Mr. Flanagan is wanting you to understand is that if you gave information to a police officer that they used in reliance on obtaining a warrant against your wife for domestic assault, and you are asked those questions today under oath, and you answer differently than that, there is a possibility that you could be subjected to criminal prosecution yourself because there's a statute that makes it a crime to give false information to a police officer. Sometimes people get mad and they say things to an officer, they make a false report. And the reason they make a false report is because they're angry, upset, or whatever, and it's not true. But sometimes people decide they don't want to really, have to see what happens, so they want to change their story. But you have to understand that when you testify today under oath, then those questions, those answers could be used as evidence against you if you change your version of what happened. You also, as a citizen of this country, have a right under the Fifth Amendment of the Constitution to decline to answer any question that might tend to put you in danger of criminal prosecution. You understand that? You understand everything I've asked, I've advised you of?
I can decline the question.
You can decline to answer a question if you think your answer could potentially put you at peril for criminal prosecution. You can decline to answer because your answer might tend to incriminate you in criminal prosecution. Do you understand that? All right. You understand everything I've explained to you?
Yes.
All right. Mr. Stevens, you may ask.
Sir, please state your name.
Joseph Miles.
And Mr. Miles, how do you spell that for the record?
Joseph Miles.
Mr. Miles, who is your spouse?
Rebecca Miles.
And how long have you been married?
It's about 3 years now.
3 years. What was her maiden name?
Rebecca Fain. Fain.
How do you spell that, sir?
Fain.
Did something happen to you on August the 1st that leads us to court today?
Yes.
And what was that?
We got in the argument at the restaurant.
About what?
She said that I was looking at a lady's butt, and I said I was talking about the bucket that had soy sauce on it.
Okay.
And she thought I was looking at the lady's butt.
Where was that at? Was
got
that in
mad
Dixon
at me.
County or another county?
It was in Bellevue,
Davidson County, to your knowledge?
Davidson.
What did she do in response to that argument?
She hit me with a fork. I think that's what it was. I had my hand laying there, and she just hit me with it.
Did you have any marks from that?
I had a little scratch on my hand.
Okay. Still there today? Still there today with a mark?
No.
Okay. Now, Mr. Miles, did you drive home after that?
Yeah.
Where'd you go to?
Went home
And where's that at?
on Trace Creek Road.
Is that in
White
Dixon
Bluff.
County?
Right in White Bluff.
Okay.
Dixon.
White Bluff, Dixon County?
Yes.
Now, on the way home, what else happened?
We argued, and it wasn't really a hit. She was just pushing, and I was kind of pushing away from her. And it was just a little altercation there, just back and forth.
Now, did you talk to an officer on scene?
Yes.
Officer sitting at court at a table with me right here.
Yeah, yes.
Now, as part of that, what did you tell the officer happened?
I told him at the restaurant we had an altercation and just had the argument.
Did you mention where she said she was going to slit your throat at bed?
I think I might have mentioned that.
Multiple times?
I think I mentioned it once.
Okay. As part of that, did you tell the officer that she hit you right up there on that hill, right at the hill you can see right here, which would have been in Dixon County? Did you tell him that?
It was on the hill above the house.
So she struck you while you were in Dixon County?
Well, we was pushing each other.
Okay. You where she's on bond for a matter, correct?
On bond?
Correct?
Oh, yeah.
Involved striking a
Like the
school
red.
bus, is that correct? Striking a private school bus that caught on fire?
Correct, yes.
And you're aware she's a convicted felon?
Yes.
You're aware that one of the charges was she had a gun in her purse?
That, I didn't know she had a gun in her purse.
You didn't know that?
No.
Were people from the family calling Officer Lewis asking for the gun back before charges were made?
Her son asked me about the gun. It was his gun.
Okay. In her purse, correct? Or you don't know?
I don't know if it was in her purse.
What pills does she take? What medication does she
That's
prescribed?
medication, moximorphone, and something else.
And she'd
for
have,
her back.
she'd have a prescription bottle of that,
His
correct?
prescription.
Would that be in her purse as well?
I think it was in her purse.
Okay. And you're aware the charges include allegations of a child and bus driver on this bus as it caught fire that she hit. You
I didn't
understand
know
that?
there was a child on the bus.
You didn't know that?
Later.
Okay. One second, Your Honor. All I have at this time, thank you.
Wallace?
Mr. Miles, you and I had talked about your wife's substance abuse problems.
Shit.
And one of the things that you and I talked about, did we not, was trying to get her treatment.
Yes.
And that this altercation, she was somewhat under the influence of that. I mean,
Yes.
basically attacked you for looking at somebody.
Yes.
Okay.
She's very jealous.
Very jealous. Our goal, when I say ours, that what you and I had talked about was to try to get her in treatment to address that problem.
Right.
And you would agree that this new arrest is basically based on her substance abuse problems?
Yes.
And you want her to get help?
Yes, I do.
Okay, that's all.
Step down, Mr. Miles. State may call your next witness. Step right up here, Officer Lewis, and we'll raise your right hand and be placed under oath.
Ma'am.
Sir, please state your name for the record.
Daniel Lewis,
And she may have already asked some of this, but how do you spell it?
Daniel Lewis,
Where are you employed?
Dixon Police Department,
How long have you been employed with the department?
almost 9 years.
Do you recognize the individual seated beside Mr. Flanagan at a defense table today?
Yes, sir.
Who is that?
That's Miss Rebecca Miles.
Based on your investigation, do you know of any other name that she has?
Miss Rebecca Fain.
Did you have an incident with her that brings us to court that occurred on or around January the 22nd of this year?
Yes, sir.
Where was that at?
It was at the intersection of 70 and 96, sir.
Is that in Dixon County?
Yes, sir.
Now, we're here at a motion, so what exactly was the basis? Did you get a call for service?
Yes, sir. We got called to an accident involving a school bus or a private school bus and a car collision.
Based on your investigation, what did it appear had happened?
From the investigation standpoint, we believed that Miss Miles was intoxicated during the wreck and hit the school bus, which ignited the school bus, making the child and bus driver get off the bus in a hurry.
Ms. Miles, did you ever collect blood from her, collect a blood sample for testing?
The hospital did, yes, sir.
Was that collected by you, sent off for testing at TBI?
Yes, sir.
What were the results of that for BAC?
I believe it was .113.
And was there something else in her body as well, oxymorphone?
Yes, sir.
Okay. Were people calling you about something for her? Was her family calling law enforcement?
Yes, sir.
And what about?
About a pistol we found in her purse.
Okay. Her purse?
Yes, sir.
What else did you find in her purse?
We found her prescription bottle of medication in there, along with some over-the-counter medications.
Okay. Was it, to your knowledge, was her name on the bottle? Do you recall?
Yes, sir, it was.
And the gun was in this purse with it?
Yes, sir.
Is she a convicted felon?
Yes, sir.
And what is that for?
Aggravated assault.
And to your knowledge, she also have prior domestic assault convictions?
Yes, sir.
Does she have prior domestic assault arrests?
I believe so.
Okay. That's all that I have. Thank you.
Flanagan?
Depends. Law enforcement third, sir.
Third?
Yes, sir.
I know, I've represented, so now I'm on the third generation.
Yes, sir.
How long have you been an officer?
About 9 years, sir.
Okay. And based on some of the questions that you've been asked, you would agree that she's got a substance abuse problem, would you not?
I've only met her the one time.
Okay.
So I can tell
I
you from
understand.
what I know from that case.
Okay, I understand, that's all.
Thank you, Officer Lewis.
Thank you, sir.
Where is your father nowadays?
Retired building trucks, so.
State has rested their rebuttal proof. Mr. Flanagan, you have anything else to
Nothing
offer?
further, Judge.
I'll hear you in argument.
As you've heard from the testimony today, in January, an incident occurred around January 22nd. You've heard proof of that before, Your Honor, involving serious allegations of Ms. Miles under a .113 along with oxymorphone, striking a school bus which caught fire with a child and a driver on it who then had to flee for safety. Additionally, inside of her purse is a firearm, and she is a convicted felon with a prior aggravated assault. Both of those are B felonies with a child endangerment under 3915-401D, as well as the 3917-1307 for the convicted felon. She made bond on this, was arrested and made bond shortly after, April 14, 2025, for a 10-count indictment, including very serious offenses, which I've noted. She was arraigned on this on June the 16th of 2025, and a mere 45 days later, we have serious allegations of domestic assault. Her husband took the stand and noted how she stabbed him with a fork in another county, but then admitted to, or spoke of, pushing and shoving while right up the hill in Dixon County. Further, he admitted that he told the officer that she said she would slit his throat. The state has serious concerns on this case. We have someone out on bond on violent offenses with a firearm as a convicted felon. And while that matter is pending and on bond, she gets a new violent offense, a domestic assault, which you heard from Officer Lewis, she has a prior conviction on. Now, I understand the defense's argument that she just needs treatment. The state is in opposition completely. Treatment will not stop this in the sense of such serious violent acts. This is not simply one DUI. No, this is a very serious offense where a school bus catches on fire and then she gets a new domestic assault with prior history of the same while she's on bond, 45 days after being arraigned in Dixon County Circuit Court. The state therefore asks that you fully revoke her bond, and I believe she's already set for a status date in October. Thank you.
Mr. Flanagan?
Well, Judge, I understand that the Assistant District Attorney is anti-treatment. This is the first time he's ever really said it on the record, but I know he doesn't like it. That's the appropriate thing here. She's presumed innocent of all this other stuff. Your Honor can leave her in this rehab center for a period of time. We can set it back when we come to court. But she's presumed innocent on everything. And the knee-jerk reaction of the district attorney, especially in this judicial district, is always to revoke their bond. They don't even consider the other alternatives, and they don't even list them in their motions. But the appropriate thing I'd ask the court to consider, let these people take her back to Mammoth, Kentucky and finish that 28 days, and we can come back in and see where we are. But that's what I'd ask the court.
The risk to her family and to society at large is too great. Thank you.
Well, the statute that the state is relying upon is pretty clear. It's under 4011-141, which states that if after the defendant is released upon a personal recognizance, an unsecured personal appearance bond, or any other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of the orderly and expeditious progress of the trial or the proceedings, then the court may revoke or terminate the defendant's bond in order the defendant held without bond pending trial when without release. Subsection B is what that provides. Subsection A of that same statute does provide that when a defendant is released before trial shall continue on release during trial or release pending trial under the same terms and conditions as were previously imposed, unless the court determines that other terms and conditions or termination of release are necessary to assure the defendant's presence during trial or to assure the defendant's conduct will not obstruct the orderly and expeditious progress of the trial. When we set a bond in a case, I didn't set this bond to my knowledge. I had no input into the setting of her bond, but apparently one of the conditions that she was allowed to remain on bond or that she obtained no new bond conditions were to keep in touch with his or her attorney. The bond was set at $50,000, and then the issue becomes whether or not there is a basis for the revocation. There's no question that the state has produced and the court has accepted as evidence the fact that she was in fact arrested on another domestic assault. There's been testimony as to her prior record of prior domestic assaults, but the only real proof that I have is that she is a convicted felon from aggravated assault, and therefore that's the reason she's being charged with being a convicted felon. However, the nature of the offense for which she is on trial and the number of charges that she's facing, the severity of those charges, and the fact that there was a danger to a minor child involved in that accident requires this court to consider whether or not allowing her to be remain on bond, even with treatment, poses a threat to the welfare and public safety to the extent that the court should revoke the bond. In considering that, the fact that she was indicted and brought before the court and less than 45 days later engaged in this type of domestic violence causes the court to believe that the bond should be revoked in full and that she is remanded to Sheriff's Department to be held prior to trial. The court is of the opinion she does need treatment, and treatment will be an option for this lady once we have disposition of the case. She is presumed to be innocent, but under these circumstances, the proof before this court from the officers involved seems to me that there's a fairly strong probability of conviction, which is one of the factors the court considers, the nature and probability of conviction in determining the amount of bond and whether or not bond should be granted. Considering all of those things, the court is of the opinion that the bond should be revoked and she should be held prior to trial.
Yes,
Motion
sir.
for the state is granted.
Thank you, Your Honor.
And in light of that, one of the things I'm going to do is I'm going to file a motion for a furlough. You've taken her into custody, and I'm going to be filing a motion, and I'll have testimony from this same people and ask the court to furlough her, but I'll do that through a motion, just so you'll know what I plan.
All right. Who else do we have back in custody?
Ready on Mr. Defendant, please.
All right. Bring up Mr. Devaney. Mr. Baker still here? Mr. Baker? Ricky Warren. Ricky Joe Warren, you have a motion to suppress, right?
I have a motion to suppress and a motion for a bill of particulars.
So that'll be for hearing. That'll be after lunch, obviously. So. Except for what? September 25th. Okay. Yes. Who is the inmate?
Christopher Devaney.
I'm talking about
Oh, I'm
a
sorry.
Department of Corrections inmate. We've got Wills and Warren. Okay, all right.
It's the same thing, we just said did on two separate. Judge, it might be confusing, but Mr. Devaney, he has a pending probation
Turn that
violation.
microphone toward you.
It might be confusing, Judge. He has a pending probation violation, plus he has other charges. He'll be pleading guilty to the probation violation, subject to Your Honor's approval. His sentence will be placed into effect. He will serve 1 year and then be released back on probation. On the new charges, he will be pleading guilty to theft between $2,500 and $10,000. He'll be getting a 6-year sentence, all suspended but 1 year. And that will run concurrent with his probation violation. He'll also be pleading to simulation of $10,000 to $60,000. He'll be getting an 8-year sentence, suspended all but 1 year. And he is to make restitution on the probation violation, restitution on both of those cases during the pendency of his probation. He'll have random drug screens. He'll have to pay restitution within time limits. So the total sentence would be 8 years, suspend all but 1 year, and then 7 years supervised probation.
All right, Mr. Devaney, raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Christopher Michael Devaney.
Mr. Devaney, you're here today on 3 different types of offenses, and I'm going to deal with your probation violation first. You understand that if you are charged with probation violation, you have the right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had actually violated your probation.
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes, sir.
You understand that if you went to that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty to violation of probation, you waive your right to that hearing and that appeal. And all I'm going to do is revoke you to serve your sentence for 1 year, day for day, and then return you to probation.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you wish to plead guilty to the charge of probation violation under these agreements?
Yes, sir.
then I find you guilty of violation of your probation order that you be revoked to serve 1 year, day for day, and then return to active probation. In these other cases, in docket number 2025 CR 139, count 1, you're charged with theft of property, and count 2, you're charged with criminal simulation. Have you seen or been shown a copy of those charges? Talked them over with Mr. Overton, you and he discussed the range of punishments you're facing as well as any possible defenses you might have.
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty to those charges according to this agreement. Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury of those charges?
Yes, sir.
You understand that trial, you would have the right to have a lawyer and have one appointed if you could not afford your own.
Yes.
You understand at trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
Do you understand that if you went to trial, you and Mr. Overton could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent, you would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out on these cases.
Yes, sir.
But you understand that's going to result in convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty according to this agreement and waive your right to a trial and to an appeal?
Yes, sir.
Do you understand if you plead guilty, the court of the state could ask you questions about these offenses, and if you answer the questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your will?
No, sir.
You understand that I can't accept your pleas unless I'm satisfied you are in fact guilty and there is a factual basis to support them.
Yes, sir.
Then are you guilty of the count of theft? Are you guilty of theft?
Yes, sir.
What did you take? What did you do overall, I guess it would be? Why are you in jail?
It would be for out-on business, and a customer sent me some money, and I didn't complete the job.
All right. And then there's a second count of criminal simulation. Tell me, are you guilty of that?
Yes, sir.
What did you do to in that particular case?
It all stems from the same. I mean, the same.
General Wojciechowski is going to let me know what the facts would be. The criminal simulation is a little different than theft. So what is the? I tell you what, step aside and let her stand at the podium and tell us what the facts are. So.
Judge, on November 14th of 2024, Mr. Devaney took a check over to First Federal Bank that had been made out to him for $9,850. Then on the 15th, he withdrew that check from the bank. This check was a fraudulent check. It had been actually made out to a different to a like townhouse for a rent, and had not been made out to Mr. Devaney. It also had been made out to a separate amount. So the theft and the criminal simulation come from the altering of the check and the theft of the money. The bank actually did give Mr. Devaney the opportunity as well to try to repay the money, and he chose not to do that. And that's the basis of the theft and the
Thank you. That
criminal
explains it
simulation.
for me. All right, Mr. Devaney, you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead guilty according to this agreement?
Yes, sir.
Are you satisfied with your attorney's services?
Yes, sir.
Feel like Mr. Overton's done a good job of representing you competently?
Yes, sir.
Mr. Overton, do you know of any reason he should not enter these pleas?
No, Your Honor.
Then, Chris, anything further from the state?
90 days to repay
Right, that is part of that condition. I didn't announce. All right, I failed to note that on the probation violation order. but there is a requirement that after you have served your 1 year day for day, that you will pay restitution within 90 days of the reinstatement of your probation. And that will be in full, and that will be a zero tolerance. What that means is that you must pay it within 90 days. If you don't, for any reason, then you'll go back to jail to serve the balance of that sentence. You understand that?
Yes, sir.
All right. Then, in docket number 2025 CR 139, upon your plea of guilty to count one, I find you guilty of theft, order that you be sentenced to 6 years Tennessee Department of Corrections to serve as a range 2 offender that will be suspended to supervised probation after you serve 1 year day for day in the Dixon County Jail. You're ordered to have drug screens at least 1 time per month and have zero tolerance for your drug screens. If they're positive, 1 positive drug screen sends you to prison. You're ordered to pay restitution in the amount of $9,850 to First Federal Bank with a minimum of $100 per month towards restitution. That will be concurrent with your probation violation. In count 2 of that indictment, you're found guilty of criminal simulation, sentenced to 8 years, Tennessee Department of Corrections to serve as a range 2 offender, suspended to supervised probation after serving 1 year day for day in the Dixon County Jail. Those same conditions will be required as in count 1. This will be concurrent to count 1 and in your violation of probation for an effective 8-year sentence with 1 year to serve day for day and 7 years on probation. All right. Thank you.
Thank you, Your Honor.
All right, what do we have left then? Anybody? So that's for a hearing. It's going to have to be at 1 o'clock. Anything else? And then we have the sentencing hearing that's set for 1 o'clock out of Cheatham County, correct? All right, I'm going to go ahead and break for lunch until 1 o'clock. Detective Johnson, if you want to come on up.